5 seconds to go. Start. This is an appeal by special leave filed by a defendant whose application under Civil Procedure Code to set aside an ex parte decree passed against him has been dismissed as barred by res judicata. To appreciate the points arising in the appeal, it would be necessary to narrate the proceedings in three litigations between the parties. The ex parte decree that was passed against the defendant, who will hereafter be referred to as the appellant, and which he sought to be set aside in the proceedings which are the subject of the present appeal, was in suit 134 of 1956 on the file of the Court of Second Civil Judge, Kanpur. But long before this suit was filed, the two other proceedings were already pending. The first of them was a small cause suit by one Fulla Cure, who sought to recover from the appellant rupees 750 on the basis that she and the appellant were partners, and by an arrangement between them he agreed to pay rupees 150 per month for her share of the profits which he had failed to pay. This was suit 1023 of 1951 on the file of the Small Cause Court, Kanpur. The appellant entered on his defense and denied the partnership and his liability to pay the sum claimed. While the suit was pending, the appellant in his turn filed suit number 20 of 1953 against Fulla Cure for fixing the fair rent of the premises in which he was carrying on the business, which Fulla Cure alleged was a partnership business, it being common ground that Fulla Cure was the owner thereof. While these two suits were pending, Fulla Cure died on July 13, 1953, and thereafter one Roop Chand Jain filed suit 134 of 1956 already referred to. Roop Chand Jain died pending the appeal in the High Court and is now represented by his heirs who have been brought on record. It would, however, be convenient to refer to the respondents as the plaintiff. Suit 134 of 1956, which was filed on May 19, 1956, repeated the allegation that Fulla Cure had entered into the partnership with the appellant under which she was entitled to get for her share rupees 150 per month. This share of profits, it was alleged, had been paid to her up to October 14, 1950, and that thereafter the appellant failed to pay the same. The plaintiff claimed to be the next reversioner of Fulla Cure, and on that basis claimed that a sum of rupees 4,200 was due to him. Besides this, he alleged that the appellant had been using the building belonging to Fulla Cure, in regard to which he was liable to pay rent, which was claimed at rupees 150 per mensum. The plaintiff also claimed that he was entitled to evict the appellant from the premises. In the result, the reliefs claimed in the suit were a money decree for rupees 9,390 on account of the items we have set out and eviction from the premises where the business was being carried on. Having regard to the contentions of the parties in the three suits, all of them were transferred by the district judge to the court of the second civil judge Kanpur on August 4, 1956, and on August 23, 1956, the civil judge passed an order directing that the suits 20 of 1953 and 134 of 1956 be consolidated for joint hearing, the evidence led in suit 134 of 1956 being treated as evidence in the other suit as well. On October 10, 1956, the appellant filed his written statement to suit 134 of 1956, in which he put forward the case which he had already been asserting, with absence of any partnership relationship between himself and the fuller cure, and that he was in possession as a tenant and could not be evicted because the requisite statutory conditions to enable the plaintiff to claim eviction were not satisfied. Needless to add that there were several other defenses which he urged, to which it is unnecessary to refer. Thereafter, there were questions raised as regards the adequacy of the court fee paid by the plaintiff in suit 134 of 1956, applications by the plaintiff to amend the plaint, etc. These took place during the year 1957. The issues were settled on February 28, 1958. We can pass over what transpired in the early part of 1958. Both the parties were attempting to effect a compromise, and for that purpose the hearing was adjourned, but the compromise was not finalized, and finally on May 24, 1958, a joint application was made by the plaintiff and the appellant that 2 months' time may be granted to them to arrive at a settlement, and that the trial, which was fixed for May 28, 1958, may be adjourned for that purpose. Stop.